So there are many issues to consider in developing that trust. And obviously the first is to determine, is the trust the best option? Now with the wealth of these other vehicles available, the trust may not be the only option. We used to develop trust for amounts under $100,000, but now with the exemption of 100,000, that's something to consider. Um, there is a cost, of course, of setting up a trust, um, and so we want to assess the cost benefit analysis of designing a trust. A trust is in fact a separate legal entity, and so it will require, in addition to the accounting to the ministry, it will also have to file a tax return every year. We call that a T3. So there's an accountability to Revenue Canada, just like you and I have every year as well. We'll want to consider the circumstances of the beneficiary and their level of capacity, perhaps, whether they're married or single, whether they have children, maybe dependents. We'll want to think about the life expectancy of that person with a disability, because if the trust is intended to cover the life of that person, we could see a trust that is actually in existence for many, many years to come. We'll want to be aware of the existing assets of the beneficiary. So as a planner, I would want to know, does the individual already have $100,000 under that exemption amount? Do they have an RDSP? And what amount is in that RDSP? I should mention that the RDSP has a limit as well of $200,000, and that is also considered exempt from loss of provincial benefits. And then the big one, which I'm going to spend a little time on now, is the whole concept of the choice of trustee and alternate trustees. Okay, so turn the page. So the age of the beneficiary is really important, obviously, because if we're setting up a trust for someone that's 19 and we expect this trust to be available for the rest of their life, it's conceivable that we could be looking at a 60 to 70-year trust. And so we want to think about, well, is that practical for a trustee to be able to manage the trust for that long? So we want to think about the age of the trustee. Are we going to have young folks? Are we going to have people that are a little bit more mature? How many trustees do we want to have? We need to think about alternates, because if we have a 60-year trust, we may not be around that long, or we may not have the time or the energy to take on that role. So it's important to think about the what ifs. What if this trustee cannot take on that responsibility? Is there a mechanism to appoint alternate trustees? Perhaps it's the existing trustees, or perhaps it might be someone that has just the ability to appoint trustees. Do we know that the trustee understands your child, your son or daughter with a disability? I know a lot of families, struggle with this decision because they might be isolated, or because they feel that it might be too overwhelming for a person to take on this role. But I think it's really important for the trustee, to have an understanding of the person with a disability. They need to understand what are their circumstances, and is there a relationship there? So ensuring that you've got that trust, I think, is so important in choosing that trustee. The other area we want to sort of contemplate is, what about the ability to remove trustees? We talked about the discretionary trust with the person with a disability being really at the mercy of that trustee. What if circumstances arise where that trustee is not acting prudently? not acting in the best interest of the person with the disability. We need to have a mechanism to remove that potentially, or to replace them with others, or even to have them resign. Um, and then another one that's really important is, does the trustee even have knowledge of the disability benefit legislation and its regulations? Many trustees will not have that knowledge. And so um, ensuring that they know how to get those answers, that they can go out and seek the necessary supports is really important.
You want to be able to have, when you say that you want to have a mechanism to be able to remove the trustee, is that mechanism something that's written inside of the trust, or is it inside of your will, or is it a clause that's written somewhere?
Absolutely. In the trust itself, or even within the will, there should be some thought. And so, any sort of a plan that you would develop with your advisor, should, you know, consider that option of what if, knowing that you might have a trust that might be in a place for many, many years. It's important to have a succession plan. And there needs to be a mechanism to enable that to happen. And if the trust is silent on that, that doesn't mean that there's not a plan. It just means that it's not your plan. And I'm a strong believer that families should make that plan for the future and not leave it to the chance that someone else will apply and take on that responsibility.
Right.
So, and I can't emphasize enough the need for trustees to gain the knowledge that they need around disability benefits, but also to ensure that if they don't have the knowledge, that they know that they can go out and get it. They can go to a lawyer, they can get the advice that they need so that when they're executing that trust, they're not going to create problems for the person with a disability.
There's actually a question about that, Ken.
Sure.
It says, is there a trustee workshop that you know of where trustees can actually get trained in that role?
Yeah, in fact, because of this issue becoming so prominent for families, I find that once we've made the decision to plan, the next big challenge is choosing a trustee. And, it used to be that folks would say, I've been appointed as a trustee and it's, such an honor. But the reality is it's not an honor, it's a huge obligation. And because of that, I actually developed a workshop, which I'm happy in the future to offer your group as well, Angela, on the roles and responsibilities of trustees, because it really is a very important session. And what I found was that when I met with families, they would have the knowledge now, they would have the education and the skills, but their trustees would not. And so we need to arm trustees as well with that same knowledge. And so what we found was that families were saying, hey, we need a workshop that actually is geared to the folks that are going to execute the plan. And so, having some knowledge about trustees is very, very important. And I'm happy to share
that would be great.
That PowerPoint with yourself, Angela, and or people that are attending tonight or others that might have an interest in just knowing a little bit more about the roles and responsibilities of trustees.
That would be great. Thank you. Just want to make sure there's not. Yep, there we go.
So the other area that we want to also contemplate is, where does the trustee live? If we're talking about a trust where the person with a disability resides in British Columbia or in Vancouver, and the trustee, let's say, is in another province or even another country, is that practical? Could they actually manage the trust fund from another country? The other thing that is important to recognize as well is that when we're talking about taxation of the trust itself, the residency of the trustee dictates the taxation of that trust fund. So if you have a trustee that resides in Alberta, but your trust is actually resident in British Columbia, from a tax perspective, that trust would be Alberta tax. And so, and that gets even more complex when you have U.S. residency issues. So if your trustee, let's say, lived in California, you now open the door to some really significant tax issues because U.S. law would deem that trust to be an asset of that person that resides in the U.S., and that's not the intention. So these types of complexities need to be attended to in designing the trust, and choosing a trustee and knowing where they live is really important. So, we might want to ensure that our trust remains British Columbia resident by ensuring that there's a clause in there that stipulates that the trust shall always have a majority of British Columbia residents as trustee, and that will then avoid that gap potentially.
There's a question. So the question is that the person would like to appoint her daughter as a trustee
Mm-hmm.
and wants to know what you say to that. And so I know you've talked a little bit about wanting to make sure that you've got the person's consent and that they have the capacity to be able to do the research and understanding and have a relationship with the person and have their best interests. Is there anything else to consider in that?
Yeah, so I mean that's a really good question, and it's a common scenario for many families. I think one of the positive things about families with children with disabilities is that they are very unique, and siblings play a big role, sometimes as big a role as the parent, in planning for a child with a disability. And so there's a lot of reliance, there's a lot of comfort knowing that that sibling could potentially take on a management of that trust fund. But unfortunately, in my world, I see the 1% where there could be problems. And one of the obvious problems is that there could be a potential conflict of interest where you have, let's say, the able bodied sister acting as trustee of the disabled brothers trust fund. And I'll add another layer to that, with the ultimate beneficiary potentially being the disabled or the able bodied sister who's also the trustee. So you create this perceived conflict where there actually could be an incentive. Again, I'm not saying that that's going to happen, but there could be an incentive to not dispersing funds, because by not dispersing funds, the person without the disability will ultimately receive that fund. So that's a perceived conflict that's in place. Now, there are ways to avoid that, and one of those ways is to simply add other trustees and ensuring that there is others that can sort of ensure that there is no abuse, that there is a checks and balances, or even having a trustee appointer there to kind of oversee and protect and ensure that the trustee is acting prudently. Trustees have a fiduciary duty, and so if they're not acting prudently, they could be held accountable as well. But the issue of exercising discretion is a challenging area. You cannot force a trustee to exercise discretion if the trust says that they have unlimited discretion to do as they see fit. So it's a real balancing act because you want to provide a preservation of benefits, but you want to have comfort in knowing that the fund is actually going to be utilized for the benefit of the person with the disability. Now, I say this, and I also realize that for many families, there may not be a choice. And it may be that the sibling is, in fact, the best choice, and 99% of the time, it is a good choice because they know their brother or sister well, and they're going to do the right thing. They've done the right thing from day one, and the expectation is that they will continue to do that when the parent is no longer around. But there are things that we can do in designing the plan to provide some protection to ensure that that appointment doesn't run into a problem in the future.
Now I see there's two more questions.
Okay?
So one says, my will states that any assets to be left to my disabled daughter are to be distributed by way of a trust. Do I have to specify that this be a discretionary trust, or is that something that my lawyer would automatically do?
Yeah, the term discretionary trust is in fact a common law term or a policy term. The words discretionary trust do not necessarily need to be actually outlined in the will, but the trust itself must contain the characteristics of the discretionary trust. So, number one, the disabled beneficiary again must have no control over distribution of the trust fund. The trustee can only have that control. There must be, again, an ultimate beneficiary beyond the person with a disability. If those criteria are met, you can have a discretionary trust. If you are in doubt, I would suggest that it would be important to confirm and perhaps review your will and ensure that it does comply with the rules and regulations around discretionary trusts. And I think people should generally review their trusts, review their wills, and even more so today with some of the changes that have been made in the last year and a half to 2 years to ensure that you're still compliant with the rules and that the trust that you have is in fact going to meet your needs. Is there another part of that
There
question?
is a second, there's another question from somebody else. What should a trustee be paid for service?
It's a great question. Trustees' compensation is traditionally guided by the Trustee Act of British Columbia, which actually outlines what is considered reasonable compensation. And really, in a very brief overview, um, there are components to fees that trustees are eligible for. One element is a capital fee, which permits a trustee to claim up to 5% of the value of the trust fund. The other component is what we call a care and management fee, and the legislation actually provides that it is 1.4%. Now, those are our top limits. It doesn't mean that your trustee is going to get those amounts. It will depend on the complexity of the trust in terms of what is reasonable. Um, the other thing, of course, is that if the trust itself does not provide specifically for compensation, and we rely then on the Trustee Act, there is also a requirement that the trustee's fees need to be approved by the beneficiary. And so we call that a passing of accounts or an informal passing of accounts. The challenge occurs, though, where your disabled beneficiary may not have capacity, and therefore they cannot consent to a passing of accounts. And then when that happens, the only way to get a passing of accounts and effectively approval of those fees is actually to go through the court, through a formal process, which unfortunately adds cost to the administration. And so that's something to think about in designing a plan. And I think the more clear that you are around compensation and awareness of compensation, the easier that process will be when you're no longer here and your trustee is, claiming compensation and determining what is reasonable. Okay. So the size and the complexity of the trust is also another important consideration. If you have a very large trust with millions of dollars in it, you're going to want to have a trustee that's going to have the ability to manage that trust to ensure that they know that they can delegate investment to other professionals such as investment advisors, versus, perhaps a really small trust, which may be really just intended for, distributing and paying for additional costs to sort of supplement that person with a disability. I touched about the issue of avoiding conflict. Another common vehicle that families I find are gradually looking into more and more now is the area of corporate trustees, and ensuring that if a family member cannot take on the role just because there are no people that are willing to do that, we may need to look to a corporate trustee. And when I talk about corporate trustees, I'm talking about banks. So any of the big banks, for example, I'm talking about estate trust companies, professionals such as lawyers or accountants, individuals that, as part of their profession, can offer a service. And of course, the advantage of these groups is that they have efficiencies. They're well versed in running trusts. You eliminate potentially that conflict, um, but you also create costs. And corporate trustees, will charge fees. Typically, they're very similar in terms of costs. Many corporate trustees will have minimum fees, so they will only take on a trust, knowing that they're going to get those minimum fees. Um, there is the challenge, of course, of a corporate trustee perhaps not knowing your son or daughter. And so I find that sometimes having the combination of corporate trustee and maybe family or friend provides a good balance, because now you can delegate the challenging areas of administering a trust fund to those that are professionals and leave some discretion to family members to sort of ensure that the wishes and the needs of that person with a disability are met, but also provide some oversight to ensuring that the corporate trustee is in fact looking out for the best interest.
And I hopefully that answered, because there was a question from somebody saying, is it better to go through a trust company? And I think that that's clarified. Is Would the fees for a trust company be covered under the Trustee Act that you mentioned, with the 5% or the
So
1.4%?
typically, a corporate trustee will actually, and this could be an advantage, they'll actually negotiate a fee with you at the time of making your trust. So you'll actually have the ability to negotiate with that prospective corporate trustee and know exactly what the fee will look like. They will also typically incorporate their fee agreement within the trust or within the will itself, so that it's very clear this is what the fee structure is. And the advantage of that is you have some certainty. You have knowledge of what the future is, and you're not now subject to some uncertainty or discretionary consideration of what a trustee might feel is reasonable under the Trustee Act. Um, I encourage families to explore options around corporate trustees and not necessarily choose one, but meet with several, and sit down with them, and talk about what their experience is around disability. Ensure that they've got a history of working with people with disabilities, and ask really tough questions. What would you do under these circumstances? Develop a plan and make sure that if you do go that route, you have some confidence that you've found the right fit. And I think the other important element is that with a corporate trustee, I think what we're attempting to build into that as well is longevity. A corporate trustee will be around hopefully for many years, and so that uncertainty of not knowing you have a trustee will potentially be eliminated.
So if you were to go with a corporate trustee, instead of naming a person, you're naming an entity. So then if somebody inside of that entity moves on and they're not your point person, there's a
Exactly.
company that's made the commitment. So like you were saying earlier, if there's a 19-year-old setting up a trust, going to need it to be managed for 60 years, a corporate entity is going to be available without the need for the alternates.
Exactly, and,
continuously.
that may be a good source of a backup plan.
Right.
So if in doubt, appoint XYZ company as that trustee, and therefore you have some longevity built into that, or enable your current trustee or even a trustee appointer to be able to have the ability to appoint a trustee and maybe a corporate trustee. So the language is really important. So when you're sitting down with your advisor to ensure that you're contemplating these what ifs. What happens if I don't have family and in the future they're not able to take on this role? Let's design a plan that will enable succession so that there's no uncertainty for your son or daughter.